I thought what I would do is just in about 2 minutes go over a brief history of how we've gotten to where we are over the last 30 years when it comes to regulation of juror names. The first entirely secret jury that we've been able to identify that was impaneled in 1977 in the trial of drug kingpin Leroy Barnes in New York City. The court in that case believed Barnes presented an unusually dangerous risk to the jurors and took the extraordinary measure of hiding their identities. Thereafter, anonymous juries were used sparsely, primarily in criminal cases where the defendant was notoriously dangerous and the court reasonably believed a fair trial could not be held without protecting the jurors' identities. In many cases, the defendant in prior cases had previously tried to bribe, intimidate, or harm jurors, and those were actions that everyone pretty much agreed were legitimate and justified limiting the identities of the jurors. Through the mid-1980s, the use of anonymous juries was concentrated in the New York federal courts and was used only in exceptional circumstances. It evolved further around the country, largely in drug trafficking cases, and again, usually in the case where jurors were we were concerned about juror safety or about jury tampering. But what we've seen in the last 8 or 10 years or so is the evolution of the use of anonymous juries encroaching or evolving into use in white-collar crimes and in some cases, anonymous juries in civil litigation. Now, we're also going to be talking about varying degrees of anonymity here. Some cases, anonymous juries mean that the actual identity of the jurors is not even known to the defendant's counsel. There are varying degrees. Sometimes when we talk about anonymous juries, and in fact the most common model is where the parties know who the jurors are, but the press and the public do not, either forever or until sometime after the jury verdict has been reached.